Hello, I'm Mark Mandel, a technology company general counsel and a co-founder of CCPA In this training course, we will cover the California Consumer Privacy Act, or CCPA, from the perspective of a manager or an employee of a business that is required to comply with the law. We are publishing this course in March of 2020 based on the CCPA as amended, including the latest draft regulations provided by the California Attorney General. The CCPA requires companies to train their personnel in all aspects of the CCPA. If you work for a business that is subject to the CCPA, this training course is intended to provide you with that legally required training. If you're following this course because your employer asked you to do so, we will provide you with a certificate of training after you complete the course if you click on the training certificate link at ccpafreetraining.com. To obtain a training certificate, please watch this entire video and answer the learning questions to be provided when you apply for the certificate. During this course, we will speak or display one or more training certificate codes, and you will be asked to provide these codes as part of the learning questions when you register for your training certificate. The CCPA requires training for everyone who either handles consumer inquiries or who is responsible for CCPA compliance within a business. That includes your customer care team, your store associates if you have brick-and-mortar stores, the teams who design your products, your engineers and IT staff who implement products, apps, and websites that collect data, and the marketing and other executives who decide which information to collect and possibly to sell. The CCPA requires broad training in the law, so we will cover the statute broadly, with a focus on everyday interactions that make up the most visible signs of CCPA compliance. Disclosures about the information the business collects, shares, and/or sells, which privacy rights the CCPA grants to consumers, the method consumers can use to exercise their rights, and best practices responding to consumer privacy requests. Before we continue, let's take a moment to consider the importance of privacy laws like the CCPA. The Fourth Amendment to the American Constitution protects our privacy, but only from actions by government and not private corporations. In this era of big data, businesses can deliver unprecedented convenience and value to consumers. As executives, engineers, marketing professionals, and customer care agents, we all have access to an unprecedented amount of personal information. We are the first generation of corporate citizens who, regardless of the industry we serve, need to consider the privacy implications of our work. And now, according to the CCPA, we need to implement strong privacy controls as part of our work. Privacy is a real freedom that influences how we feel and how we act. We know this is true because most people behave differently when they're being watched. Just think of all the people who sing in the shower and not on the sidewalk. Maybe you are one of them. Compliance work, particularly mandatory training, can feel like a burden. I hope the idea of privacy as an important freedom will give a sense of purpose to the work we undertake in implementing corporate privacy programs. Compliance regimes like the CCPA leave enough room for responsible data use that both delivers great business value and enables transformative consumer experiences. There is an art to finding that middle ground, and I hope the remainder of this course will provide a pathway to it. The agenda for our course consists of 6 topics: notifying consumers about your data collection practices and their CCPA rights, what infrastructure you need to accept consumer requests, how to verify requests before you respond to them, when and how to respond to requests, how to document your CCPA compliance, and how to handle special situations such as offering incentives to gain access to consumer data and collecting data from children. Before we move on, I'll note that while I am a lawyer, this training course is not legal advice. CCPAFreetraining.com is not a law firm, and of course, watching this video does not make me your lawyer. If you do need legal advice, feel free to contact me at mark@ccpafreetraining.com, and I can connect you with one of the lawyers that we trust. The CCPA provides privacy rights to quote-unquote consumers, meaning any resident of California. While businesses may deny CCPA rights to residents of other states, as of March 2020, a Nevada privacy statute provides an opt-out right similar to the CCPA, and about a dozen other states are considering comprehensive privacy bills. See the FAQ at ccpafreetraining.com for an updated list of state privacy laws before deciding which of your consumers are entitled to privacy rights. Now that we know who the CCPA rights apply to, let's examine what personal information about them is in scope for CCPA. When some people think about personal information, they think about bank account numbers, location history, and the contents of their chat messages with friends. All of that private information is part of the personal information protected by the CCPA, and the CCPA protects much more than that. The CCPA considers personal information to include anything that can be associated with a particular person or household, such as your name, email address, or a grocery list. Even if your name or contact information is a matter of public record, it's still personal information under the CCPA. Other examples of personal information include your gender, your image, voice, location, search history, purchase history, even potentially the IP address of your phone or PC when it connects to the internet. Finally, personal information includes any inferences that can be drawn about you from other information. For example, if your browsing or purchase history suggests you're a wine lover, that interest category is part of your personal information. The definition of personal information is central to the CCPA. Keep it in mind as we explore consumer rights under the law, and note when I refer to data in the remainder of this course that is shorthand for the data that is personal information under the CCPA. Now that we understand who has CCPA rights and what personal information means, let's examine what you need to tell consumers about your use of their personal information and how to present that disclosure. The CCPA requires businesses to notify consumers about privacy at or before the point at which the business collects the information. This could mean signage outside of a brick-and-mortar store where you're using video surveillance, or a website banner that informs visitors about online information collection. Provide your notices in every language in which you ordinarily transact with or advertise to consumers. To comply with point-of-collection requirements, companies are expanding their ubiquitous banners that ask consumers to accept cookies to refer more generally to information collection, use, and disclosure. Here's an example of best practice from a convenience store chain with a banner that contains disclosure about cookies and information collection and sharing. As you see here, a notice can consist of a brief summary and a link to a full privacy policy explaining what information a business collects and why. Businesses that quote-unquote sell personal information also need a "Do Not Sell My Info" link in their homepage footer that leads to a means for consumers to opt out of personal information sales. You can see that behind the banner, this convenience store has also included a "Do Not Sell" link in their homepage footer. Note that the CCPA's definition of sell is broad and includes a variety of transactions not normally thought of as a sale. For example, many companies that assist with online marketing will use the data they collect from your consumers to enhance their own marketing databases, and this can be a sale even if they don't pay you for that use. If you want to be sure you're not selling data to a particular vendor, ask them if they'll agree in writing to be your quote-unquote service provider for CCPA purposes. This restricts their data usage to serving your interests only and will ensure the transfer is not a sale. Now that you've provided any applicable "Do Not Sell My Info" disclosure and linked consumers to your full privacy policy, let's look at the requirements for that privacy policy. Your policy should explain what information you collect and why. That disclosure is a basic feature of privacy policies, so if you already have a policy, it likely already covers the what and the why. Planning for CCPA compliance is a good time to read your privacy policy to make sure it's up to date. Talk with your product teams, marketers, and other data stakeholders, and make sure your privacy policy covers all of their sources and uses of data. What you need in your privacy policy that's new for CCPA is an explanation of the 4 core consumer CCPA rights and how to access them. First is the right to know about the information your business collects, discloses, and sells. The right to know includes the consumer's right to receive general disclosures in your privacy policy about the categories of data your business collects and discloses within the last 12 months, and the categories of third parties it was sold or disclosed to. For example, your privacy policy might disclose that you collect browsing analytics data and email addresses, and that you sell browsing analytics data to an ad targeting platform, and that you merely disclose email addresses to your email service provider for use on your behalf. The right to know also includes a consumer's right to receive individualized disclosure about the categories of information collected, disclosed, or sold about them, plus the right to obtain a copy of the actual information you collected about them. Your privacy policy should also inform consumers about these individual rights. The second of the 4 core CCPA rights your privacy policy should explain is the right of consumers to request that you delete their personal data. This includes all of the data you would have disclosed to the consumer if they made a right to know request. However, there are broad exceptions to this right that permit businesses to keep data even after a consumer requests it to be deleted. We'll review those exceptions in Part 4 of our agenda when we cover how to respond to consumer requests. The third core CCPA right is the right to opt out of data sales. We've already discussed the broad definition of sale underlying this right, and your privacy policy should explain this right to consumers. If a consumer chooses to opt out of sales, you should stop making any data transfers that would constitute a sale, and you should wait 12 months before asking a consumer if they would like to opt back into sales. The fourth core CCPA right is the right to non-discriminatory treatment. Your privacy policy should explain that if a consumer exercises their privacy rights, you will not treat them any differently than other consumers, for example, by charging them a higher price or by denying them services. Note, however, that the CCPA does not entirely prevent businesses from offering consumers incentives for using their information. Loyalty programs that provide discounts in exchange for data use are still okay if implemented according to CCPA rules. We'll discuss those rules under Part 6 of our agenda, Special Situations. In addition to explaining each of the core CCPA rights, your privacy policy should explain how to access them, and we'll cover that next in Part 2 of our agenda. Before we leave the topic of what to include in your privacy policy, note that the CCPA allows consumers to designate an agent to make requests on their behalf, and your privacy policy should also inform consumers about this, including what proof you require to confirm the authenticity of requests that may come from an agent. In Part 2 of our agenda, we'll discuss the contact methods that businesses must make available to consumers for them to exercise their privacy rights. You need to offer at least 2 contact methods for consumers to exercise their privacy rights. The first method is an interactive web form or an email address. If you don't sell data within the meaning of the CCPA, an email address is acceptable as your first contact method, and otherwise you must offer a form. Since web forms are easy to implement and provide an opportunity to receive requests as structured data, an advantage over email, we recommend that all businesses implement a web form as a best practice. We talked earlier about the Do Not Sell My Info link that is required in your homepage footer if you sell data. Clicking that link should lead to your interactive web form, and here we see an example of an implementation of this form by a pharmaceutical company. Note my company CCPA Toll-Free provides this web form. The second contact method you need to offer is a toll-free number. This is a requirement for accepting right to know and delete requests. There is an exception for businesses that never interact with consumers offline and who have a direct relationship with all of their consumers. However, given the data collection that comes in online advertising and offline marketing activities, relying on this exception is either impractical or impossible for many modern businesses. That said, there is no requirement to staff a call center to handle toll-free number requests in real time. Instead, you can find a toll-free number for CCPA that uses a phone menu and voicemail system to turn these requests into structured data. Here's an example of how an enterprise solutions company implemented the 866 I Opt Out toll-free number service for privacy requests, placing it in a section of their privacy policy dedicated to the CCPA. Note my company CCPA Toll-Free provides this privacy hotline. Finally, if neither of your first 2 contact methods reflect the manner in which you primarily interact with consumers, you need to offer that method as a third method. For example, if consumers primarily interact with you by shopping in your brick-and-mortar stores, you could provide a paper form available in the stores to accept privacy requests. While this primary method requirement applies only to opt-outs and making additional information available to consumers who have questions, as a best practice, we recommend accepting all CCPA requests via each of the contact methods that you offer. Note if any of your methods to opt out of sales or to delete information offer a choice applicable to less than all of a consumer's information, you need to offer a choice to opt out or delete all information more prominently than the partial choices. In Part 3 of our agenda, we'll discuss verifying consumer requests. After you accept a request through one of your contact methods, if it is a request to obtain a copy of consumer data or to delete consumer data, your next step is to verify it. In those cases, the CCPA requires you to establish, document, and comply with a reasonable method for verifying that the person making the request is the consumer the request pertains to. Note if the request is to opt out of sales, you are not required to verify it. The CCPA provides detailed guidance about how to verify consumer requests. Make the verification process proportionate to the value of the data at issue. In other words, if a consumer requests a copy of more sensitive data, such as location history, the process for authenticating the request should be more rigorous than if the request was for a copy of less sensitive data, like a music playlist. If a consumer has a password-protected account with you, you can require them to log in to make the request, but if they don't have one already, you can't require them to make one. If a consumer without an account makes a right-to-know request for the categories of information you hold about them, you need to verify at least 2 data points about the consumer. And if they make a request for the actual information you collected, you need to verify at least 3 data points about them and obtain a declaration signed under penalty of perjury that the information requested is about them, and you need to keep these declarations in your CCPA records. For delete requests, verify 2 or 3 data points depending on the sensitivity of the information. If you want to use a 2-step verification process, for example, emailing a consumer to click a link to confirm their delete request, this is okay. Just explain this process in your privacy policy. Verify consumers without obtaining new information if possible, especially sensitive information like government identity documents. If you do collect new information, either delete it after verification or keep it with your CCPA compliance records only and don't use it for any other purpose. Use reasonable measures to detect identity fraud and to safeguard personal information. If you suspect fraud, don't comply with a request unless you're sure it's genuine. If there's no reasonable way to verify a consumer, you can deny the request and explain why. This could happen, for example, if someone interacted anonymously with your website. You might still have relevant data in your log files and have no way to match it to the consumer. Finally, make sure verifying requests does not require the consumer to pay any out-of-pocket fees, or if there are fees, e.g. for a notary, that you reimburse them. The CCPA treats requests to opt out of sales differently than requests for access to data or to delete data. You are not required to verify opt-out requests. You may do so, but you need to make the process easy for consumers with minimal steps, and you cannot impose any steps that would impair a consumer's decision or ability to opt out. In Part 4 of our agenda, we'll examine the CCPA deadlines for responding to requests and what information you need to include in your response. First, let's talk about timing. When you receive a right-to-know or delete request, you need to acknowledge it within 10 calendar days, informing consumers about your verification procedures and when to expect a substantive response. You need to fulfill the request within 45 calendar days, and you can ask for an extension to 90 days if you notify the consumer that you need extra time and explain why. You also need to complete your verification procedures within these deadlines. If you receive a request to opt out of sales, you do not need to make an initial acknowledgement. Instead, you need to fulfill the request within 15 business days. For all types of requests, respond free of charge and always comply to the extent possible. If there's a reason you cannot comply, explain it, and also explain your appeal procedures if you offer a right to appeal. For right-to-know requests, consumers can request either a copy of the specific data that you collected or information about your sources and uses of that data by category. For both request types, respond based on your last 12 months of activity from the date you received the request. If a consumer requests information about the data use by category, you need to provide 1. The categories of data collected, such as contact information or purchase history. 2. The categories of sources it was collected from, for example, ad networks or the consumer's web browser. 3. The business purposes for which you collected each category, for example, order fulfillment or marketing. 4. The categories of third parties you sold or disclosed each category of data to, for example, IT infrastructure partners or marketing agents. And 5. The business purposes for which you disclosed or sold the data, for example, order fulfillment and marketing. Individualize these responses unless your responses would be the same for all consumers. If a consumer requests a copy of the specific data you collected, never include government identification or financial account numbers, passwords, biometric data, or other highly sensitive information. You can also omit any information that isn't easily accessible to you if you maintain it exclusively for legal or compliance purposes and you inform the consumer about the categories of records that meet those criteria. Use reasonable security when transmitting information to consumers. If a consumer has an account with you, you must provide their information via that account, and otherwise, you need to give the consumer a choice between receiving their information via postal mail or electronic delivery. If you can't verify a consumer making a right-to-know request, don't release any information and direct them to your privacy policy instead. If you can't verify a consumer making a delete request, respond by offering to treat it as an opt-out of sale request instead of a delete request. While you don't need to verify an opt-out of sale request, if you use verification procedures and you reasonably believe a request is fraudulent, you can deny a request on that basis if you inform the consumer about your reasoning. For delete requests, the CCPA gives you wide latitude to deny a request if you need the data to comply with laws, to identify errors, to maintain security, to provide services to the consumer, or for reasonably anticipated internal uses, such as financial reporting or product improvement. If you deny a delete request because you need the data for one or more of these purposes, inform the consumer about these purposes, and then, going forward, use the data only for those purposes. For data you must delete, you can 1. Delete it, 2. Render it anonymous or de-identified by removing the information associated with the consumer, or 3. You can aggregate it with other data so that it is not capable of being associated with the consumer. There's no need to tell consumers which method you used. For your computer backups, you can delay deleting them until the next time you access them. Finally, inform consumers that you'll maintain a record of their delete request. For opt-out of sale requests, wait at least 12 months before you ask a consumer to opt into sales again. However, if the consumer requests a transaction or service that requires opting in, you can request an opt-in at that time. When you receive a request to opt out of sales, take action on a go-forward basis. There is no need to inform third parties you may have sold the information to previously. However, once you've received the opt-out request, if you sell any information to a third party before you process the request, you do need to instruct that third party not to further sell that consumer's information. Whenever a consumer opts in to the sale of their personal information, use a two-step process in which the consumer first makes a clear request to opt in by any available method and then separately confirms the request. For example, by filling out a web form and then clicking a link in a resulting email. If a right-to-know or delete request comes from a consumer's agent rather than directly from the consumer, you can require the consumer to demonstrate that they've authorized the agent in a signed document by asking them to provide you with a copy of it, and you can separately verify the consumer's identity. If an opt-out request comes from an agent, you can only require the agent to submit a document signed by the consumer, proving that the agent is authorized to act on the consumer's behalf. If a consumer uses opt-out settings in their browser or device, you need to respect those, and you should treat them as direct requests from the consumer. This is a change from current law that generally allows companies to ignore do not track settings in operating systems and browsers as long as they disclose that fact in their privacy policy. Under the CCPA, consumers have the right to request information about their household instead of just about themselves. If there's a password-protected account associated with the household, you can process requests as per your usual procedures via the account. If there's no related account, then you should only process right-to-know requests or delete requests if all household members join in the request, and if you verify the identity of each of them and their status as a household member. If a member of the household is under age 13, obtain parental consent before disclosing household information. Note, we'll review the rules for working with children in more detail in Part 6 of our agenda. Whenever you receive a request, whether you can verify it or not, and whether you ultimately respond to it or deny it, you need to maintain records about your CCPA compliance. The CCPA requires businesses to maintain compliance records for 24 months, including the date of the request, what rights were exercised, the contact method used to make the request, the date of your response, the nature of your response, and the basis for any denial if you denied the request in whole or in part. If you have help desk ticketing software, you can use it to fulfill this requirement, and otherwise you can keep a spreadsheet or use dedicated privacy compliance tracking software as shown here from CCPA toll-free. Make sure to use reasonable security in keeping these records and use them only for compliance purposes. If you receive a delete request, do not delete your compliance records. If you process information from more than 10 million consumers in a calendar year, you need to update your privacy policy to include certain statistics about each year. The number of requests to know, to opt out, and to delete received, how many requests you complied with versus denied in whole and in part, the average number of days you took to complete each request type. For requests you denied, report how many were unverifiable, not from a consumer, sought exempt information, or something else. You can publish these statistics for all privacy inquiries, or just those from California consumers, as long as you maintain separate internal records about California consumers. We'll wrap up our training program by covering two separate topics: children's privacy and the CCPA's rule prohibiting discrimination against consumers who exercise their privacy rights, and the exception to that rule. The CCPA does not require you to know or to ask how old your consumers are, but if you have actual knowledge or a strong reason to know that a consumer is under age 16, you need to obtain opt-in consent before selling their personal information rather than providing an opportunity to opt out of sales. Different rules apply for consumers younger than age 13 versus those aged 13, 14, and 15. If a child is younger than age 13, an opt-in to sales needs to come from their parent or guardian, and you need to verify that person's status as a parent or guardian using a reasonable and documented method. For example, you can obtain a sworn statement that is signed and mailed or scanned, confirm using a payment card, or check and then delete a copy of a government ID. Note these rules are different than the rules for verifying an adult consumer's identity, where the CCPA encourages you to do so without requesting new or sensitive information, such as a government ID. For children aged 13 to 15, the child him or herself can opt in using the same double opt-in procedures that apply to adults who opt in after opting out of data sales. For opt-ins of children of any age, always inform the parent or child of their right to opt out again later and how to do so. While there are similarities between the CCPA and the federal children's privacy law called Children's Online Privacy Protection Act, or COPPA, compliance with the federal law is not a substitute for compliance with the CCPA, and vice versa. In other words, even if you obtain parental consent under the CCPA, you must continue to comply with COPPA. For consumers of all ages who exercise their CCPA rights, it is important not to treat them any differently as a result. The CCPA forbids discriminating against consumers who exercise their privacy rights, for example, by charging them a different price, providing them with different goods or services, or even suggesting that you will do so. However, the CCPA does allow businesses to maintain loyalty programs, freemium business models, and even to pay financial incentives for consumers for using their data if these programs adhere to certain parameters. The key consideration for these programs is that any difference in pricing or services or any payments you offer must be reasonably related to the value of the consumer's data to your business. To provide an incentive program, you need to explain your price or service difference, or the payments you provide for the retention and sale of consumer data, including the program terms, how to opt in and out of the program, an estimate of the value of the consumer's data, how you calculated that value, and how that value relates to your program features. Disclose these terms where consumers will see them before they opt into the program, and make the disclosure disability accessible. A deep link to a relevant portion of your privacy policy is sufficient. To calculate the value of the consumer's data, consider factors such as the average value of the data in the marketplace, your revenue impacts from the sale, collection, or deletion of data, and your expenses related to data collection and to the provision of your incentive program. If you are unable to estimate the value of the consumer's data in good faith, or if you cannot show that your program features are reasonably related to that value, the CCPA prohibits you from offering the program. Thank you for participating in our training program. Please leave any comments in our YouTube channel or email me at mark@ccpafreetraining.com if you have any questions or if you would like to see additional training modules that focus on topics such as product design or vendor management. We value your feedback, and if you're looking for tools to help with your privacy compliance, we would love to share with you what we've built at ccpatollfree.com. As a training course participant, you're entitled to receive a 20% discount on our privacy tools. Email training@ccpatollfree.com for details.